Good afternoon, Mr. Khallil.
Good afternoon, Chief Justice, and good afternoon to all the commissioners.
Okay. I just want to apologize for keeping you waiting. We are running behind schedule, but it's not all that late in the day, so I hope you do not suffer too much.
No, that's fine, Chief Justice. Thank you very much.
Okay. You studied law at the University of Durban, Westville.
That is correct, Chief
obtained
Justice.
BA Law and LLB. And then you did articles. Was that in Durban?
Yes.
But then you went to the bar.
Yes.
When was that?
That was in 1995.
95. And you practiced as an advocate until 2008?
No, until 2003, Chief Justice, when I was appointed in March as an acting magistrate.
Oh, I'm looking at your JSC questionnaire, and it says you practice as an advocate from 15/5/95 until 28 February 2008. Is that a mistake then?
No, that is correct. For 7 years and 9 months, I did practice as an advocate.
Oh, okay. And then you started in the magistracy in an acting capacity.
That is correct.
How long did you act as a magistrate?
Just over 3 years. I think it would be 3 years and 4 months or 6 months.
You were additional magistrate, you became a control magistrate, then senior magistrate.
Yes,
And you have been a magistrate for 21 years now, not so?
that is correct.
All right. You've acted as a judge.
That is correct.
Where? Just tell us about your acting stints.
Yes, I acted initially in 2012 at the end of the year, 2013, and it was for 2 5-week periods. And thereafter, in 2022, that was at Durban High Court. And in 2022, Chief Justice, I acted on 3 occasions. That was 2 in Pietermaritzburg High Court, and the last one in Durban High Court.
Did you get an opportunity to write judgments during those acting stints?
Yes, I did, Chief Justice. And when working it out, I think it may be between 40 to 50 judgments during that 5-week period, or 5 weeks on 5 occasions that I would have written.
Any of them reported?
To the best of my knowledge, 1 was reported.
All right. In which division did you act?
KwaZulu-Natal.
KwaZulu-Natal.
Yes. Durban and Pietermaritzburg.
Yes. But then you've applied for the Eastern Cape vacancy as well. Not that there's anything wrong with that. You are a South African and you can apply to work anywhere you want in your own country.
Yes, Chief Justice. When I thought about the applications or accepting the nominations, one cannot be confined to KwaZulu-Natal. And as an acting chief magistrate, I've done hundreds and hundreds of acting applications for magistrates. I'm well aware and I appreciate the constitutional imperatives, particularly in terms of Section 174(2). And also the realization that if I want to serve my country, the largest population of Indians outside of India would be in KZN, and that may cause certain challenges to me. So, but if you want to serve your country, if you're patriotic, and if circumstances allow, you serve anywhere where your country would see that you are fit to serve your country. So it's on that basis that I did apply for quite a few posts.
What kind of practice did you run as an advocate? What kind of cases did you do?
Yes, I did civil, I did criminal. Most of the criminal that I did was pro deo work in the High Court and the Regional Court. I did divorces, personal injury claims, defamation cases, a wide variety of cases.
Have you had an opportunity to do civil work as a magistrate?
Yes, I would say initially most of my work was civil work in the magistrates court, and thereafter, particularly after I got an opportunity to act in the high court, there was more criminal. So I would think or guesstimate that it's quite evenly balanced between criminal and civil.
You've also worked as a commissioner in the small claims court.
Yes, Chief Justice, I still currently do serve as a commissioner in a small claims court. The attorneys and advocates do a wonderful job in servicing the small claims court in our communities. But we do have problems now and again where the attorneys may be held up in the high court or with other duties, and I then step in to preside in the small claims court.
And you have experience in the equality court as well.
Yes, Chief Justice, I would have done maybe about 15 or 20 equality court matters in Durban as well as at Verulam. And other courts. I think in Scottsboro I did one.
Do you have any reserved judgments or part-head matters?
No, Chief Justice. There were just one at the time of my application for the various posts being considered currently. But that was a partly heard matter which has since been finalized and judgment delivered on the 30th of August this year.
All right. All right. I will give AJP Ntlangulela an opportunity to put questions to you.
Yes, certainly.
Thank you, Chief Justice. Mr. Khallil, you have just been asked a question.
I'm sorry, I can't hear you, AJP. Can you pull your mic closer?
You have been asked the question regarding where you have applied for the purposes of appointment as judge. You have applied to Mthatha for appointment in Mthatha, and where else?
KwaZulu-Natal, Mthatha, Limpopo, and Western Cape. I did also apply for, I didn't show any preference wherever there was a vacant post for a judge at entry level as such. I applied for that, but I was not shortlisted for Gauteng.
Okay. And I would like to believe that you have applied for appointment in KwaZulu-Natal because you are born and bred in KwaZulu-Natal.
Yes.
Have you worked outside KwaZulu-Natal at any stage, even if as magistrate?
Yes.
Where?
I've done some work in Pretoria for the Magistrates Commission. It was an appointment for misconduct proceedings against, I think it's a regional magistrate in Pretoria. I've worked in the Southern Cape at George, also conducting misconduct inquiry involving a head of court at the magistrates court level.
Okay. Any contact in the Eastern Cape, even through relatives? Do you have relatives in the Eastern Cape?
No, I don't, AJP. But I do know some, or at least one judge on the Eastern Cape division. We were at university together.
Who's that, Daud?
Yes.
Oh. I ask you this question because of concern that I have as the head of the court at the moment, that if you have never gained experience of interacting with the peoples of the Eastern Cape, you might have a problem, given that your family is in KwaZulu-Natal and everything of yours is in KwaZulu-Natal, and also given that you're not young anymore.
Yes.
Were you hoping to relocate perhaps? Let's say if you were to be appointed?
Yes, I've given serious consideration to that. Insofar as it pertains to interacting with different communities, or although I do understand it's in the context of KwaZulu-Natal, but there are various communities. I've never ever experienced any problem my entire life in interacting at any level, whether it's through the justice system or outside of the justice system, with any community. Language at times is an issue. I do understand that and appreciate that. But apart from that, I've never had any issues or problems. If I meet somebody, I would greet them in their language or try my best to greet them in their language, the little that I know. It just endears you to so many people, and the respect just when you try, at least. But I don't foresee it as any problem or any challenges in relocating. To relocate, it's not AJP, the entire family that would relocate. The children are grown up and have their own lives. It would be myself, my wife, and my mother. So it would not be a huge relocation. And getting to engage with communities, that's a process in South Africa that we all must undertake.
Yeah, but would it not be fair of me to suggest to you that if you were to be engaged as judge and based in Mthatha, invariably you'd need to touch base from time to time. That is, go home, meet with family, wife, children, and so on.
With the children, yes, but the wife would be with me and my mom. I have a very small family as well, a big extended family, and there were a few deaths in the family over the last few years. So most of the time, it's just a small unit.
And it also must follow that you've never acted, you've never experienced a stint of acting as judge anywhere in the Eastern Cape.
No.
Be it Mthatha, be it Bisho, be it Makanda, be it Gqeberha.
No, I have not.
I see. You have done from your papers I've read, there's a case that you have presided over. That is the case of Njongwana. Am I right? I saw one of your written judgments. There's one relating to Njongwana. Do you know the origins of that Njongwana?
I think he comes from the Eastern Cape.
Eastern Cape.
The family. The father was a former diplomat. His mom was an attorney or law lecturer as well.
Okay.
This was all in the evidence.
Okay.
In the matter.
Okay. CG, I have no further question.
Thank you. Premier Mabuyane, are you there?
Yes, Jay, I'm here. Thank you very much. Good afternoon to you, and good afternoon to all commissioners.
Good afternoon.
And also good afternoon to the candidate, and good luck to him. Firstly, CJ, if you may just allow me to use the opportunity to congratulate you. The first JSC meeting after your appointment. Congratulations to your appointment, and all the best.
Thank you,
Largely,
Premier.
thank you so much. Largely, I think so far I'm covered. I might as well request to come back later. I think your questions and questions from the acting chief, judge president are almost covering me so far. Also, my problem, I'm traveling. My network is not that strong, but I think I'm covered so far with questions that have been imposed. So, but I'll come back if there's an issue that I want to.
Okay, I may as well just mention now, Premier, because your province regularly has candidates appearing before this body, that you are going to stop the practice of people who are supposed to participate in the interviews joining virtually, especially the premiers and similarly placed participants, because they give us trouble. We should not have to worry now that you're traveling and may get cut off any minute now. It's just not proper. I'm just putting you on warning. Okay.
Thank you very much. I take it.
Thank
I'll
you,
come
Premier.
there.
Okay.
Thank you so much.
Commissioner Kies?
Thank you, Chief Justice. Good afternoon, Mr.
I can't hear you at all, Commissioner Kies.
Good afternoon, Mr. Al Khallil.
Mr. Khallil.
Mr. Khallil.
Khallil, yes. Good afternoon, Commissioner.
All right, I'm sorry. Right. You have, I will ask this question because I understand that you have applied to all the divisions that were on offer.
Yes.
Every, to suggest that you might be a desperate person. I don't want to say that. The Chief Justice has different interpretation. I have different one. My point is, you are aware that, for instance, as you are applying for the Eastern Cape, I believe that you have read the Eastern Cape Joint Practice Directives.
Yes, in 2022, in January, I did read it.
No, what I'm saying is that in each of the 5 or 6 divisions, that's the essence of my question that we're applying to, you have read the practice directives applicable to that division. In this case, we have read the Eastern Cape practice directives because those directives, they are uniquely applied to that particular division. We have read them.
Yes, in January 2022, not specifically for the purposes of the interviews, but when I went to act in the High Court in KwaZulu-Natal in 2022, I had a look at about 6 different divisions of the practice directives.
No. I'm sorry. We'll end up on this. I have a few questions.
Yes.
My question is, have you read the Eastern Cape practice directives?
Yes.
Because we are applying to the Eastern Cape, you should be interested. That's what every judge in the Eastern Cape must know.
Yes.
Okay. Can you tell me what does Rule 12, subparagraph 4 of the Eastern Cape Directive say in relation to the launching of agent application in that division?
In regard to the?
Relation to the launching of agent applications in that division. That is in the Eastern Cape Division. What does rule?
I'm not so sure about the fairness of that question.
Okay, let me
Commissioner
say.
Kies.
Okay, let me forget about the rule. Let's say, is there a difference in the bringing of agent application in the Eastern Cape compared to other divisions, whether it's Gauteng or Limpopo or Western? Is there any difference?
No, I wouldn't be able to answer that without having a look at the practice directives and refreshing my memory on that. But what I can say generally, not specifically about the Eastern Cape, is that the practice directives are not uniform in quite a number of the divisions of the High Court regarding urgent applications. In some divisions, you would require a certificate of urgency, for example, to be filed by counsel or the attorney, and in other divisions, not. So I wouldn't be able to say that unless I have a look at the practice directives now. I can't remember. I would just be guessing and clutching at straws if I were to answer your question directly.
Yeah, I'm asking that because any judge, if you are appointed today, you
Yes.
have to do duty. The
Yes.
first thing, in the Eastern Cape, there is a practice that they have.
Yes.
So I thought to do any judge, any person apply. The second question, let's leave that you don't know.
Yeah, sorry,
Yes.
can I just make one comment there, Commissioner? Yes, it is expected of you that whichever division you are appointed to, the first thing that you would do is you would read and acquaint yourself with the practice directives. So even if it means within a couple of days or so, that is expected of a judicial officer to acquaint themselves with the practice directives of whichever division.
Just a follow-up on that one, CJ,
Yes, Commissioner Malem?
which you ruled that it's an unfair question. It is not. He asked him if he has read the practice directive many times, and his answer was yes. Then he referred to a clause. Then he further left the clause and rephrased the question. What does the practice directive say when it comes to agent matters? Because it's different. And that's a fair question. If you have read, in terms of maybe section this or that, it might be unfair to be direct. But as a general practice, in terms of practice directive of Eastern Cape, because you said you read it, what does it say when it comes to agent application?
Thank you. I said I read it at the beginning of 2022, and those were not the only practice directives I read. But for the purposes of this interview, no, I have not read the practice directives.
Can we conclude that you don't know the practice directive as you are sitting there of the Eastern Cape?
Yes.
Thank you.
Just before you put your further question, Commissioner Nukies, I just want to clarify something, Commissioner Malem, for the benefit of all, that the unfairness I alluded to related to expecting the candidate to memorize the practice directives and know with specificity that clause 11, subsection 2, subsection I. Now that is grossly
Accept
unfair.
that.
The rephrase question, the general question on the substance of the role that was sought to be asked on was fine. I have no problem with it. On that note, you may proceed, Commissioner Malem.
And like as you are applying for the Eastern Cape, I listened to your debate with the acting judge president. As I understand in the Eastern Cape, judges rotate from Tata to Grahamstown, PE, and all courts in the Eastern Cape, they are there. Now with you, have you checked how will that impact on you if you are appointed in the Eastern Cape? Remember, your family is in Durban, we are not there, but you are appointed and we have to rotate. This week, we are in Mthatha, and the following week, we are in Port Elizabeth, we are in Grahamstown. Have you checked onto that?
No, but I am aware that I may be required to rotate, and I don't foresee that as any problem whatsoever. Even if today I was asked by the Commission to go to any area in South Africa to do any piece of work, I am prepared and I'm willing and able to do, and I have done so. So I don't foresee traveling from place to place. Often as a magistrate, I'm also required to travel from place to place. And I don't see that as a problem at all.
With your leave, CJ, if you allow me just the last question, because I've asked 2 questions.
And while I'm thinking about that request, I may just point out that I work in Johannesburg. I live in the Free State and in the Eastern Cape. So the last question, speaking for myself, I would put no value on it.
Now,
Ask your third question.
the last question. Now, this question, it has nothing to do with the other matters that I've. You are in a motion, we are a duty judge in the Eastern Cape, we are at PE, in Fort Gqeberha. on a Friday, the litigant approach you on a matter seeking for hearing on an urgent basis.
Yes.
When you consider the matter, you feel that the matter can be heard in motion court or it can be heard now, you can hear it. How do you go about? How would you go about in dealing with that matter?
On an urgent basis?
Yes, like on a Friday, you are a duty judge, parties want to have an agent. How should they go about? Let me put that one.
Well, if the matter serves before me, I would obviously have to decide on the urgency. But I think what you're suggesting to me is that it may be 50-50, it can be heard on that Friday afternoon, or I could say come on Monday, that's also urgent. And I think it would depend on the nature of the relief. But if the question is geared towards whether I am averse to working on a Friday or doing the work on a Friday and would just say, no, just leave it for a Monday, I think the nature of the urgency would determine that. And may I just add, Commissioner, that there have been lots and lots, in fact, hundreds of time, both in the lower court as well as in the high court to a much lesser extent during my acting stint, where I've done matters on Fridays, I've done matters on Saturdays, I've even done matters on Sundays where it was urgent enough. So I don't foresee a problem with dealing with the matter.
Okay, thank you, Sujay.
Nonkonyan?
Just wanted to complete the Eastern Cape factor. Thank you, CJ. Advocate Khallil, good afternoon.
Good afternoon, Commissioner.
Yes. In your practice in KwaZulu-Natal, as you have told us, and somewhere else.
Oh, he is a magistrate, a senior magistrate.
Oh,
Yeah.
yes. Sorry, I thought it's an advocate. But yes. Where you have been practicing law as a senior magistrate, did you consider any matters pertaining to traditional communities there? That would be my first question.
Yes. No, thank you, Commissioner. Yes, there have been a few matters that I've dealt with at the lower court level, in other words, the magistrates' court level, involving traditional leaders. For example, usually it's in the context of somebody passing on and there's a dispute between the families regarding the burial, or it may be two families that lay claim to a body. And it was a matter of then engaging with the traditional leader of the area. If I remember, the last one was sometime last year. They don't come with a formal application as such. These are traditional communities that look for assistance and just come to the court. It was late on a Friday afternoon. And what I did was, how I dealt with the matter is that I had telephoned the other side from my chambers while the traditional leader and some family members were there. I held a telephone conference in order to try to reach some consensus. I introduced myself, and after about an hour or so, the matter was resolved. That is at the lower court level. I've had a few matters like that. At the High Court level, I dealt with opposed motions dealing with the removal of an Amakosi in the Pietermaritzburg area. This was an opposed motion brought under Paja, where the Premier removed the Inkosi of a particular area. When the former Inkosi had passed on, his brother was appointed and the wife was not around, and the son was of tender age. And I had held there in that matter that as it did not meet the requirements of the constitutional requirement of a fair, lawful and reasonable administrative action, that the Inkosi was not given an opportunity before he was removed, I had made the finding that it felt to be set aside. Regarding the substitutive order, it was suggested to me and argued that I was in good a position as the decision maker or the administrator to make an order appointing the inkosi. I declined that order for the simple reason I thought that referred it back to the administrator. There should be consultation with the community in the form of an imbizo, and where the community discusses these types of matters and comes up with resolutions, the decisions are more readily acceptable. They feel part of the process, and in any event, public participation is part and parcel of a constitutional imperative. So I declined making a substitutive order on that basis. Another matter I dealt with, but you asked about the customary law. It was a customary marriage where there was disputed that there was a marriage, again on the opposed motion basis in the High Court. And my finding was that because of all the requirements, there was the Lobolo negotiations, there were a ceremony. There was a ceremony that was held. There was an exchange of gift. The bride was taken, and an animal was slaughtered, and she was given the part of the animal to cook for her new family. So, those are the types of matters that I can remember dealing with either customary law and the traditional courts and the training of the Amakosi. I wasn't involved in that, but assisted in some way to facilitate that. There were other magistrates who were involved, and I think this was a request by the former Chief Justice that Sajay undertakes the training of the Amakosi.
CJ, my second question. I think the acting judge president and my colleagues that spoke before me did actually, in a way, try to elicit something from you about your capability to be able to dispense justice in the Eastern Cape. Did you consider whether you'll be in a position to deal with complex traditional community issues, particularly in Umtata? And did you make a research? And if so, can you then be able to convince us whether you'll be a fit and proper person to really be of value in dispensing justice in that division, bearing in mind that the community in which you are going to be is predominantly a traditional community? That would be my last question.
Yes, thank you. I am confident that I will be able to deal with that. Where it comes to complex traditional or cultural issues of the communities, it is expected of you when you're serving in whichever area to learn about the communities, to read up. That's part of your patriotic duty. For example, even in KZN, some may say it is largely a rural province, but I have been to the traditional courts just to see how they operate. I have mentored an inkosi, or she was an inkosi in a particular area, and she studied law, and she then was appointed as an acting magistrate. I learned as much, where you get the opportunity about traditional courts. You read up on it. You read up on the constitutional imperatives. But regarding a particular area, certainly it's part of one's patriotic duty and also to assist in the administration of justice to read up about these things once appointed to a particular area. Now I may have a very generalized and very basic knowledge But once you're appointed to an area, it's expected of you. You can't simply just go to court and not know about the people, not know about the areas, the traditions. So it's something that, if it's complex, I would undertake research on that, as I've done whenever I've had any matters.
Thank you, CJ.
Commissioner Malem?
Thank you, CJ. No, I just wanted to follow up on customary marriage as to what is your take, because we're only allowed to ask 2 questions. But so customary marriage is recognized by our own law, and that's why you are able to even make or deal with a matter like that before you lobola and all of that.
Yes.
And by its very nature, is ordinarily married in a community of property.
Yes.
If you get married customarily,
Yes.
that is marriage in community of property. And then you go and get married in a civil marriage, and then you sign antenuptial contract. When you divorce, which law take precedence over the other, and why? Because all of it is the law.
Yes, thank you. South Africa has an integrated justice system, or a hybrid system, and it involves the Constitution as the supreme law, common law, statutory law, and very importantly, customary law. So in deciding that matter, I would think, Commissioner, how you would go about it is to say and invoke the principles of Ubuntu. And when one reads a person's judgments, one would be able to tell whether a person just talks about things such as Ubuntu and traditional law and customary law, or whether one evidences that in one's writings. So what I would do is I would try to find a way in which I can give proper credence to customary law, because it's on an equal footing with the common law in our country, or that's how I understand it to be. And what about compassion, the values of mutual care, interconnectedness of people? These are all traditional African equity values which falls under the umbrella of Ubuntu. So I will consciously, as a judge, look for ways in which I can incorporate that into the decision that I do make.
So, which means that, which I have a problem with, and you can clarify me
Yes.
as a legal practitioner. Now, the customary marriage, which is the married in community of property, and I get married in a civil marriage, and then you sign antenuptial contract. Why is that marriage of civil marriage even recognized when there is a recognized marriage? Before the dissolution of the first marriage, you allow a person to marry again, the same person on different arrangement. Why is that allowed? Because if customary marriage was recognized the way you want to describe it, it was supposed to be that you can't marry again because you are married, you are legally married. That should be a requirement before we get into civil marriage or any other marriage. Is there any other type of marriage you are involved in? And if it's true, I'm engaged in customary marriage, which means marriage in community of property, I must not be allowed to engage in another marriage, because the impression is like this civil marriage is more senior than our marriage. Why is that allowed?
Well, pre-Constitution, that was the case, as we all know, that very little credence was given to customary law. And with the advent of the Constitution, I think the playing fields have been leveled. But perhaps maybe we fall short in our judgments that we do deliver at times in emphasizing that and having it on an equal footing. The only example I can think of, Commissioner Malema, would be that if we'd chosen the path of a secular state, that's the cause we adopted as a country. And then if you look at the public holidays, for example, you'll have certain religious holidays which are still public holidays, and other religious holidays are not public holidays. And you don't want to be seen to be giving preference, having adopted that. And why do we still continue as a country with such? But I think practically what happens is that people are allowed in whichever field they are, whether it's in public or private enterprises, to take those as paid holidays, even though the law may not have changed to recognize that. In practice, it does happen. So I would think, Commissioner Malema, on that question, I will grapple with that, with those issues, because I understand how important and appreciate customary law is. In fact, if I had a matter, I would prefer to go to the traditional courts if I could help it, because of the equity, because of the fairness, because of the powers it has, and to do real justice on an equitable basis. It's just a personal preference.
Sorry, Chief Justice, if I
Follow up, CJ.
Well, all right. I suppose all of us want to follow up.
Go ahead, Commissioner.
Yeah, thank you. The problem, Mr. Khallil, is that I'm really struggling to grasp your answer to the questions that have been asked by Commissioner Malem. I don't understand what your answer is, because you start by saying if it was before you, you would try by all means to apply customary law, and then you start on referring to other things that are not part of the question, which have to do with language.
Yes.
Now, this is for me giving me a serious problem, because, if you were to ask someone, what was the magistrate's answer to Commissioner Malema, I don't think anyone will tell you what the actual answer is. So I'm trying to get clarification about whether you understand customary law or not. So let me ask you a different question to try and make it simpler, and ask you to please give the answer to the question and not re-ask your own question and then answer your own question.
Yes, thank you.
If there is a dispute between Party A and Party B about the rule of custom, Party A says, and it can be any rule of custom, it can be a rule relating to marriage or a rule relating to succession, any rule. Party A says the rule is Y, Party B says the rule is Z. How do you go about, as a judge, resolving that dispute?
Thank you. The question is much clearer now, Commissioner. Thank you very much.
No, it's a different question. It's not Commissioner Malema's question.
Yes. No, but the way you explained where I had my shortcoming, I would look at both versions like any other version. I would acquaint myself with customary law. I would, if needs be, call on the assistance of somebody who's well-versed. But most of the time, I would think I would read up on that and research that as much as I could to come up with an answer.
No, this is the problem. There are cases, right, starting all the way from 2003 in
Yes.
the Constitutional Court, that explain the method that the judge must follow in resolving a disputed rule of custom. They don't start off by doing as much research as I can. And so I come back to this thing that I'm trying to understand, does this candidate actually know customary law? The question started with Commissioner Nongonyana, and then Commissioner Malema localized it to marriage, and I'm trying to broaden it. Now, the sense I'm getting is that you're not actually familiar with the rules applicable to resolving evidentiary disputes and legal disputes in customary law.
Well, what I would do is, I'm not sure, you mentioned about the Constitutional Court, but the way I would approach is like any other matter. I would just do as much research as I could to understand and appreciate it, and then make a ruling on it.
Thank you, Chief Justice.
Commissioner Mr I Khallil, you had a follow-up question.
No, I think the issue has been exhausted. I have a different question, Chief Justice. I'm not sure if I
No,
should
then
go
you'll have
ahead
to
or
wait your
wait
turn.
time.
There are people
All right,
ahead
no
of you.
problem.
Okay. JP Mlambo.
Thank you, Chief Justice. Good afternoon, Mr. Khallil.
Good afternoon, Judge President.
I would like to explore this. I would have asked follow-up questions from the AJP's questions about you applying to a division you've never acted in.
Yes.
Now, the first basic question, CJ, could I just get some leeway? Because this is a very important issue to
Yes,
us heads of court. Let's just get one thing out of the way. Your experience is largely in the magistrate's court. Am I correct?
That is correct, JP.
Does that on its own equip you to take a permanent appointment as a judge?
I would think not. I don't think it would be a bar, but I would think not. You would rather prefer a candidate who has acted and who has proven themselves, even if it be to a limited extent. That would be the safer bet on a judge. So my answer is no.
Thank you. Now, you specifically mentioned that you applied in a number of divisions. You were not shortlisted in Gauteng.
Yes.
You mentioned that specifically.
Yes.
Now, the AJP tried to tease out of you, and I think Commissioner, I call him Jola. Sometimes I forget his real surname because I respect him too much. Commissioner Nojesi. If, as you say, you've acted in KZN and only in 2022, if you apply to a division that is high volume and the intensity is high, where you've never acted in, why should you be shortlisted and appointed there?
Yes. JP, I think that different divisions of the High Court are different. Some are high volume. I understand in Gauteng how busy it is. It's always better, I think, and even we do it when we appoint magistrates or recommend magistrates for permanent appointment at the appointments committee, or even where I do acting appointments of magistrates. It's always better and safer to take somebody who has acted in a particular division because you know them best. But if you talk about a high workload, when I acted in 2022, I've also acted in 2013 and 14, JP. But when I acted in 2022 and even earlier, I worked 7 days a week, Monday to Sunday at Chambers. The volume may not be as high as in Gauteng, but it's just the passion that you have. You're wanting to learn, you're wanting to do as much as possible that drives you to that. So even if the volume is high, you may not have an assurance that I may be able to deal with it.
Recording stopped. Recording in progress.
But one knows oneself, JP. But I would agree that it's always better to get a candidate from who has acted in your division, especially if it's a busy division.
Okay. I would extend it to further than just busy divisions. You need to know the court that you want to be appointed to. I think your previous statement now fortifies that answer.
Yes.
Yeah. Now, you mentioned you acted in 2013. That was in criminal work. I'm talking about civil work.
I only did civil work for 3 sessions in 2022.
Yes. So, what then is the advisability, or maybe you can tell us,
Yes.
Did you look at all the divisions that you applied to and decided that you can work in those divisions, despite you not having acted in them?
Yes. It was not an easy decision to make. It's not as if you just, at the stroke of a pen, just intend to apply to all divisions. There comes a stage in your life where even personal circumstances do not militate against you traveling and serving your country wherever. I think I've reached that stage in regard to my personal circumstances. Regarding one acting in a particular division, I don't think it can be a bar to somebody's appointment that they must have acted in that particular division. If that were to be the criteria, one of the criteria, I think with respect, that would not be fair. It just simply would not be fair. But I do appreciate you'll have to really study the candidate properly and whatever they have submitted to make such a decision, especially where they have not acted in your division.
You see, this is my last question, CJ. I asked you these questions to try and dissuade you from this thinking that you can simply parachute yourself into any division that you've not acted in, especially in the High Court. I want to illustrate it this way. You mentioned that when you acted in 2022 for the civil work, during weekends and after hours, you're in chambers. I know as I sit here that that type of work environment applies in the High Court, not in the magistracy. That's why you will never find reserved judgments from magistrates, because of the intensity and the complexity of High Court work. Do you admit that?
Yes, certainly, Judge President. The High Court work is at a different level. It involves, that is not to say that you are not busy in the magistrate's court, but the High Court work is at a different level, the intensity, the research, and you have to be totally dedicated and committed.
And the other reason is that's why the High Court sits on appeal to judgments of the magistrates.
That is correct.
But
JP.
here's my last question, CJ.
No, I did give you leeway.
Oh, the last one.
JP Malambile, I appreciate the questions you're asking.
I will, okay.
I have a discretion to give people leeway where I think it's necessary. Go ahead.
Thank you very much. It appears to me that it was your decision to apply to all these divisions. Let me tell you of this unwritten convention.
Yes, JP.
No one applies to become a judge. The convention is you are recognized by your peers and they will nominate you or they will recommend you to a particular head of court to act. You see, the three of us sitting here, we never applied to become judges. We never thought or dreamt of becoming judges. And here we sit today. Thank you, CJ.
Thank you, JP. You want to respond to the last comment?
Yes, thank you. Thank you, JP. I fully understand and appreciate what you've said. I just wanted to say that by applying to all these for all these posts, I did not do it with the intention of parachuting myself. I thought, had I applied just for KZN, I may have been legitimately criticized as why am I only applying for KZN? Don't I want to serve my country in other places? But I've understood the context in which you've explained what you've explained, JP, and I appreciate that. And I will indeed bear that in mind.
Commissioner Pillay?
Thank you, Chief Justice. Good afternoon, Mr. Khallil.
Good afternoon, Commissioner.
I just want to raise one of your judgments with you, and that's the only if judgment at page 35 of your bundle.
Page 35.
This is a judgment in which the plaintiff approached the court to implement a service level agreement with the municipality.
Yes.
And the municipality had raised a collateral challenge.
Yes.
Against the contract. If you look at paragraph 52 of your judgment.
paragraph 52.
Yes, at page 48.
Yes, thank you.
You conclude there that you are satisfied that justice would be served in allowing the municipality to rely on a collateral challenge. But you also say, despite it not having sought a declaration of invalidity.
Yes.
Now, those two findings seem to contradict each other because the very nature of a collateral challenge is that it's raised as a shield against the operation of administrative action, and that the person raising it doesn't ask for ancillary relief.
Yes.
And the problem is perpetuated in the next paragraph, paragraph 53, where what you do is you invoke section 1721A of the Constitution to grant just and equitable relief consequent on upholding the collateral challenge.
No, I did not grant any relief.
You say that section 1721A enjoins the court to declare invalid any law or conduct that it finds to be inconsistent, and then you say the award of the contract accordingly falls to be declared invalid and unlawful.
That's right.
So you do that, you invoke 1721A.
Yes.
Now, the issue I'm raising with you is that as our law stands at the moment, a court that upholds a collateral challenge doesn't necessarily exercise powers under section 1721A. The very nature of a collateral challenge is to merely operate as a shield. And so what you've perhaps inadvertently done is develop the common law without necessarily applying the test to whether or not it was competent or appropriate for you to develop the common law.
No, I don't quite understand that. I understand the collateral challenge to be a challenge to the validity and enforceability of an administrative action. And it is raised in proceedings like it was done in the only if case that was not designed to directly impeach the validity of the administrative action. But from the development of case law, particularly from the Constitutional Court and even the more recently, I think in 2020, the case of Makodo municipality, that I allowed that challenge because I thought that the interest of justice served in that particular circumstances. And I refused to make any order as envisaged under subsection 2, I think it is, where a just and equitable order, and I think that's the Gijima's case, where the court declared the contract to be invalid, but preserved the parties' contractual rights to the agreement.
Perhaps just go back and look at the cases, Mr. Khallil. The point I'm raising with you is that you don't necessarily have powers under 1721A. I'm not saying that you shouldn't.
Yes.
Perhaps you should have, but in order to get there, you needed to develop the common law. The case law as it stands now means that a collateral challenge is only raised as a defense. You don't ask for ancillary relief as a result of a successful collateral challenge.
Yes.
Thank you, Chief Justice.
Commissioner Mangen.
Thank you, Chief Justice. Good afternoon, Magistrate Khallil.
Good afternoon, Commissioner.
Yes. In the list, on the list of the judgments that you sent to us, there is a judgment of Stewart versus Pile.
Yes.
Yeah. Are you able to go to that judgment? There's just one thing that I want you to clarify for me.
Yes, certainly. If you could direct me to the page, Commissioner.
On page 54
Thank you.
of the paginated bundle, paragraph 2 of that judgment. You say, you make reference to the trust, and you say in the statement that the trust was registered in the Pietermaritzburg Deeds Office.
Yes.
Is the trust registered with the Deeds Office or the Master's Office?
With the Deeds Office or the Magistrates?
Master's Office.
Masters. I think at the Master's Office.
So we can accept that that's an error, or what happened there? You signed off that judgment?
Yes, certainly I did.
Okay. Without verifying?
No, with verifying. Perhaps the deeds office, I think practically that's where the trust is registered. But it should have been the master's office. I concede that. I can't argue differently.
I know you're confusing me.
Okay, I accept what you're saying. It should be the master's office and not the deeds office. And in paragraph 2, it makes reference to the deeds office. It should be the master's office.
Okay. Now, thanks. But secondly, the case dealt with Section 26 of the Insolvency Act, dispositions of property without value. And as I read the judgment, I established that the defendants did not testify. But then you made judgment in favor of the plaintiff on the basis of the evidence or record coming from the inquiry, Section 418 inquiry.
Yes.
On what basis did you regard that record as admissible evidence when the trust was not the subject of the inquiry?
Yes. So the question again is specifically, sorry, I didn't get that question. I don't want to go on, just to understand the question. Why did I admit the evidence under the inquiry admissible in the civil trial that I did when the trust did not testify, or anybody on behalf of the trust did not testify? I'm not too sure. I'm not too sure about the facts. I can't remember now. But had there been any issue with the admission of that evidence, that may have been sorted out at the pre-trial, and therefore I admitted that evidence. And if one reads the record, there was no objection to that. But that's not the reason why I would have made the judgment that I did make. I think the judgment speaks for itself. But just from memory, there were various dispositions made within the 2-year period to the trust, and it was an amount of about 3 million or so, and the trust received, I think, 66 million, and it was clearly a Ponzi scheme that was being operated. And the defendant did not lead any evidence to the contrary to show that it was made for value or to establish any defense in law. And that's why I would have entered judgment in favor of the plaintiff in that matter.
I don't want to debate it further, Chief Justice.
Thank you. Commissioner Marumwagai?
Thank you very much, Chief Justice. I want to pick up exactly where Commissioner Mangena left off. And perhaps maybe, good afternoon, Magistrate Khallil.
Good afternoon, Commissioner.
If I may take you to page 54, I think, of the bundle.
Yes.
That we are having, and of course the discussion that you have just had with Commissioner Mangena.
Yes.
You are quite right. That case was about a trust that invested. I mean, a trust that invested in a company with those amounts that you referred to.
Yes.
And of course, there's a paragraph where you are saying, or the heading where you are saying that relevant law, and you are referring to Section 26 of the Insolvency Act. And clearly you are dealing with impeachable transactions or voidable transactions, if you like. My challenge then, and perhaps maybe if you can clarify to me here, does it necessarily fall, whether the matter was defended or not, does it necessarily follow when a judge is dealing with an impeachable disposition case, and to grant an order, even though the actual disposition has not been indicated to have prejudiced the insolvent, either company or the insolvent person? Does it necessarily follow? In other words, when the joint equity task of joint trustees apply to impeach a particular transaction, the fact that that application has been made, and you are saying that the transaction has no value, does it necessarily follow that as a decision maker, you are going to impeach that transaction?
No, it does not necessarily follow automatically follow, Commissioner. But in this, yes.
You are quite right. Because the thing is, in this particular matter, you are dealing with the concept of no value. And the Supreme Court of Appeal has dealt with that issue in a snowball decision. And you refer to it in footnote 12. But next to it, you say, i.e., I'm not sure, are you there?
Yes, I am.
Yeah. Then you say, i.e., pro quid quo. But that principle was rejected in that very same case, where the court said, not for value means no value at all. So what I want to understand, did you read that judgment and try to understand its effect in relation to what we are dealing with?
I take that point.
Because your IE
yes.
does not, is not what the court held in that case.
Yes. No, I take that point. I understand that point, Commissioner.
Well, on that view, CJ, let me leave it at that point. Thank you very much, CJ.
Thank you.
All right. It does not appear that there are any commissioners who want to pose questions to you any longer. Unless there's anything you want to bring to our attention, Mr. Khallil?
No, just one thing that had occurred to me after Judge President Mlambo had explained what he did explain to me. I do have some misgivings in applying for so many positions, and but it's fine. So I'm going to come another 3 times a year. I don't know, but I do understand and appreciate what the JP has said. And I wanted to tell the JP as well that when we do appointments for acting magistrates, and at times we sit on the committee as well that makes the recommendations to the minister, the fact that a person has acted in a particular court, it is an important factor that is indeed considered. It is by no means the most important factor, but it is a factor that is also considered. And all things being equal, you would rather take or recommend the candidate that has acted in that particular court as opposed to somebody from the so-called outside. So I do have certain misgivings now regarding the conventions and what the JP has explained to me.
All right.
And I thank the JP for that.
All right. And I just remembered that I wanted to correct an error I made as I was leading you on your career history. I pointed out that you did your articles with success, but then went to the bar. But then you did not go to the bar. You practice as an independent advocate, not
Yes.
so? Yeah, that's that.
No, CJ.
Commissioner Mali?
Because I
Mike,
don't,
please.
yes, I don't think the magistrate understood what the JP said. It's not about applying to many places. As an unwritten rule, you don't apply. Your peers recommend you for acting, and your peers will nominate you. That's what we're saying, not applying to many places.
Yes, I did not apply. I was nominated by a very senior person for the various positions. So I do take that you don't apply, and I fully understand that. So when I said I appreciate what the Judge President had explained and the conventions, that's what I meant, Commissioner Malema. Thank you very much. Is that it, Chief Justice? All right. Sorry.
Sorry, my mic is off. It's been a long day. I was just thanking you, Mr. Khallil, for making yourself available for this position and coming here today. And I wish you all the best.
Yes,
You're excused.
Thank you very much, Chief Justice, and thank you very much to all the commissioners.